Hello friends, in the series on the income tax cases, today we will discuss a case in which a issue was before the tribunal that where the assessee surrenders some income in the survey conducted against him and the revenue do not have any corroborative evidence in respect of those surrender, then if the addition is done by the revenue, so whether in that case, in the absence of any corroborative evidence, whether deeming provisions under section 69B, which talks about of amount of investments not fully disclosed in books of accounts, or section 69, which talks about unexplained investments, and in consequence, section 115 BBE should be applied. Or in other words, if the addition sustains, then whether this addition should go as a normal business income or under the deeming provisions. This issue has been taken up by the Chandigarh Tribunal A bench in the case of Gurinder Makkar versus Deputy Commissioner of Income Tax, and this case has been reported in 111 ITR Tribunal at page number 274. In the present case, there was survey under section 133A on Assessee. In that survey, the assessee surrendered some income in the form of expenditure on building done by the assessee. When the assessee gave the statement, then there was no evidence before the revenue that this expenditure has been done, but the assessee has admitted that this expenditure has been done by the assessee, or in other words, you can say that the statement was without any evidence of the additional income which has been offered by the assessee. At the time of filing the return of income and at the time of assessment also, the assessee sustained to his statement and did not retracted that statement, or in other words, the assessee honored that statement. When the assessment was going on, the assessing officer applied the higher rate of tax section 115 BBE and invoked section 69 by saying that this is unexplained income. The assessee was saying that this was business income. The assessee was strict to his statement. The only apprehension of the assessee was that it should not be taxed at the rate of 60%, it should be taxed at 30%. When this matter went to the tribunal, because the assessing officer applied the rate of 60%, the tribunal said that in the present case, it is a trite law that whatever the statement is taken under section 133A and that statement is without corroboration, then that statement do not have any evidentiary value. In the present case, the tribunal said that the deeming provisions are not applicable at all and they are taxable as business income at normal rates. The reason for saying this was that because the revenue was not able to produce any evidence, or the assessee was not in the material or the evidence that suppose that it is an unexplained income, simply because some surrender has been done, and if that surrender is not in accordance with the evidence collected by the revenue, that only because of the surrender that income cannot be taxed at the higher rate. The second issue in this case was that when this income was surrendered in the form of expenditure on building, then the assessee was saying that now it has become the cost of the building and the depreciation should be allowed to me. But the assessing officer did not allow the depreciation. So on this point also the tribunal said that even if there are no discovery of bills and the assessee has surrendered that income and the revenue has collected the tax on that, so the assessee becomes very much eligible to claim depreciation on that. Third issue in this case was that the revenue has disallowed some expenses under section 48(3) because the assessee has incurred that expenditure in violation of section 48(3), and after disallowing that expenditure under section 48(3), the revenue was taxing that income under section 69 by saying that it is an unexplained expenditure. For this, the tribunal said that once an expenditure has been done and section 48(3) is attracted, then from this it is very much clear that the expenditure has been done. So in that case, when it is very clear that the expenditure has been done and it is recorded in the books of accounts, then it cannot be said that there is unexplained expenditure, because already the revenue is invoking section 48(3). So both the section 69 or 69 family and section 48(3) cannot be applied simultaneously. Friends, this case is very important because this case throws light that additions on the basis of solely the statements of the assessee does not have value. They have value only if the revenue is able to collect the various evidences against the statements given by the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Gurinder Makkar versus Deputy Commissioner of Income Tax, and this case has been reported in 111 ITR Tribunal at page number 274. The matter has been decided by Chandigarh ITAT A bench and the date of the judgment is 21st February 2024. Thank you, friends.